Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Judge Netburn has ordered that evidence that, according to Attorney John Deaton, may have been exculpatory for Ripple CEO Brad Garlinghouse in particular, will remain hidden. Yes, the evidence will remain hidden. Here's a tweet from XRP community member and attorney James Filan. Breaking. Judge Netburn denies Garlinghouse's motion to compel production of the Estabrook notes. The court states that, quote, Estabrook's notes are no different from the notes the court previously found to be protected by the privilege, end quote. So what's being discussed here are notes that were produced by an SEC employee named Matthew Estabrook. And these notes were created during a meeting between Ripple CEO Brad Garlinghouse and then SEC Commissioner Elad Roisman. It was in November of 2018. Matthew Estabrook is just sitting there like a fly on the wall, taking notes as they were, as Brad and former SEC Commissioner Roisman were just discussing various things. And this is the meeting, you may recall, where Elad Roisman, who again is one of 5 people on the planet that votes on whether or not to bring legal action against individuals and entities for alleged securities laws violations, and he apologized for Brad Garlinghouse for even having to be there having this meeting with him. And he did tell Brad Garlinghouse that he didn't believe that XRP was a security. So Brad's already publicly stated this. Why are these notes so important then? Well, because if the same information came from the SEC itself, in this case it would have been notes from Matthew Estabrook, that goes to show that Brad Garlinghouse wasn't being reckless. It'd basically be exculpatory. The case would effectively be over if that would be the case. That would be such damning and strong evidence. And so unfortunately for Brad, the judge, in this case Judge Netburn, ruled that this evidence was to stay private. So I'm going to give you all the specifics, but I'll tell you, in the end, this isn't going to be highly destructive for the plaintiff's case. And I'm also going to share with you the specifics now that this has happened from Attorney John Deaton and perspective also from Attorney Jeremy Hogan. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, to make sure everybody's sufficiently caught up to speed, I'm going to run through this article from February 25th this year, which covers the topic. It's from Finance Feeds, titled XRP Lawsuit. Hogan and Deaton agree SEC beats Ripple over Estabrook notes. And you'll actually see a little bit later in the video, I'm kind of surprised over part of what Attorney Deaton had to write this afternoon after this ruling came down, because he noted that he was wrong, but according to this article, he was actually right. You'll see what I mean as we go through this, but anyway, let's jump into this part now. The plaintiff has submitted the notes to Judge Netburn for in-camera review, that means in-person review, but opposes their production to the defendants because the notes are no different from SEC notes this court has already held are protected by the Deliberative Process Privilege, or DPP for short. According to the SEC, the notes should remain protected by DPP because Mr. Estabrook took the notes because he believed they could relate to future commission decisions. The same thing happened in a previous Hester Peirce meeting, and it was considered privileged by the court. Of course, I'll pause and note, Hester Peirce, an SEC commissioner also. She's one of the 2 commissioners that did not vote to bring legal action against Ripple and the Ripple executives. Piece continues. Such notes are pre-decisional and deliberative, and piercing the SEC's privilege is unwarranted because Garlinghouse's need for the notes is significantly reduced given his presence at the meeting, the SEC argued. So let's pause right there. Apparently that argument ended up winning out, we found this afternoon, but stating that his need for the notes are significantly reduced since he was there, to me it just doesn't ring true, because if the SEC is saying the same thing, to me it just seems like it would make it that much more powerful. So why would the SEC fight the production of these notes? Well, I'll tell you this. If those notes proved the SEC's point, they'd be throwing them at the court. Be like, yes, please take a look. So whatever's in there it's not just about privilege. It's not helpful to the case. That's what I suspect to be the case anyway. Piece continues. Ripple requested the Estabrook notes earlier this month and argued these were not protected by DPP. And here's a quote. Notes taken by SEC staff in context of fact-gathering with third parties, i.e. not the SEC itself, do not fall within the scope of the DPP, even if the information gathered may later be relied on for future policy making, said Ripple in its motion to compel. Here's another quote. As with other notes this court ordered the SEC to produce, there is no evidence that in the Estabrook notes, certain facts were recorded while others were purposely omitted as an exercise of judgment or deliberation, or that such a decision was made to assist with agency decision-making, end quote. Yeah, so after this happened, the whole thing was fishy, too. You may not recall, or you may or may not recall, Mr. Estabrook decided that he was going to make a career move and leave the SEC. That was announced in January of this year. And up to that point, he was asked for if he had any notes specifically on this. He didn't have anything he claimed, but then he magically found them as he's on his way out the door. A little peculiar right there. And then he ended up signing a sworn affidavit that the intent of these notes was to potentially help with future deliberative processes. So suddenly it became worth that. And it all just seems so silly to me because Brad Garlinghouse was in the damn room. It's like, bitch, whatever you wrote, it's not that big of a secret, in all likelihood. And to the degree that it would be, I don't know why he wouldn't just redact. Like, why? What about the portions that are relevant? Are they suddenly no longer relevant? I don't know. But anyway, then there's this last section of this clip to get you all caught up to speed on what Attorney Hogan and Attorney Deaton had to say as this was going on. So this is as of the end of February. As the judge prepares to rule over the Estabrook notes, attorneys Jeremy Hogan and John Deaton commented on this battle between the SEC and Ripple. And here's a quote from Attorney Jeremy Hogan. I don't think the judge orders these notes be produced. The SEC does a good job of laying out its argument in the first part, and I think the second and third arguments are particularly compelling. If the SEC wins this motion, remember, it's a small battle in this litigation, end quote. So there you go. Attorney Hogan was correct on that, and it's really not the end of the world, but still disappointing to whatever degree. Anytime the SEC gets any victory, but I will say this, in all the pretrial stuff, it's way more been in favor of Team Ripple, I'll say that, just to be perfectly honest and fair. But that's because the SEC's got all sorts of bogus claims. They're getting swatted down left and right because they have stupid claims, and they're a bunch of assets. Here's a quote from Attorney Deaton now, and this is, again, at the end of February this year. Jeremy is on point as usual. Because Brad Garlinghouse was at this meeting, he is aware of what was said and discussed. Judge Knepper already ruled Ripple couldn't have the notes from other meetings Garlinghouse or SBI, its largest shareholder, were present for. That's a quote directly from him. Which is why it's interesting, you'll see later on, he's like, I got this one wrong. I'm like, based on that you didn't. So maybe I'm probably just missing a piece of information. But here's the deal. See, these notes, they must not, the Estabrook notes, must contain not just highlights of what occurred during Brad's meeting with Roisman, who was, again, then the one of the 5 SEC commissioners. It must not just contain notes about the meeting, as if it were a transcription or something to that effect. Because in order for the SEC's privilege claims to stand here, Mr. Estabrook must have included personal opinion in the notes, as that's the only way this could stand. The judge indicates as much by stating that these notes do reveal the SEC's internal deliberative process, and not just quotes that occurred during the meeting. It's important to note the judge did review these notes herself in their entirety. And, I was hoping that if this was found to be the case by the judge, that only portions of the notes would be redacted and the rest would still be admissible. But none of it's admissible. We don't get any of it. It's not just redacted. I don't know why you can't do that. Maybe there's a perfectly reasonable explanation, but I'm just sitting here thinking if there's stuff that's in there, having to do with XRP specifically, and it shows, yes, what Garlinghouse stated is true, we can't have that? Or is that just not a part of these notes somehow? Because that seems like a key piece of what would have happened during the meeting. Why can't we just have a redacted form? All sorts of other stuff gets redacted. It is what it is, though. And so then there was this from Attorney John Deaton. This is what he said this afternoon upon this news breaking. I admit I got this wrong because I predicted Judge Knepper would order the notes produced. I believe she would find the notes privileged, but pierce the privilege because Brad Garlinghouse has no other way of obtaining the evidence, and because it was likely, unlike the SBI meeting, exculpatory. The judge disagreed, finding this meeting no different than the meeting with SBI. She is basically saying since Brad was present at the meeting, he can testify to exactly what was said and any impact it had on him and Ripple. Without reviewing the notes, it's hard to truly evaluate. Yeah, exactly. That's kind of what I was getting at even just a second ago. Without me being able to personally take a look at these notes, I can't say to what degree I would agree or disagree with Judge Knepper. But again, I tend to give her the benefit of the doubt. I think that she's doing a good job to this point with all the pretrial hearing stuff. Even the stuff where we're not so happy that the SEC gets little wins. I think she's operating in good faith, to be honest with you. It would be a little weird if the SEC didn't get even small wins along the way. Wouldn't that be a little peculiar? Then you'd start thinking, okay, is she biased in favor of Ripple? But I don't think so. Of course not. I don't think she's biased one way or another. I think she's just trying to do what's right here. Then there is this from attorney Jeremy Hogan. This is from just a few hours ago. I expected the SEC to win this motion and agree with the judge insofar as she reviewed the notes and applied the DPP factors. Also, as I tweeted back in February, I don't care too much. Garlinghouse was on the call and he can testify about what was said. Uncontroverted. Why fight this uphill battle? Well, number one, because Ripple wasn't 100% sure what was in those notes, and so it was worth a chance. It was a chance worth taking. I almost read that wrong. Number two, these are the notes that the SEC found, in quotation marks, after the fact, and it makes the SEC look sloppy/bad, and you always want to highlight that to the judge. So there you go, perfectly good reasons to give it a whirl, even if it wasn't likely, and maybe even Ripple's attorneys thought, well, this is a little bit of a long shot, but let's give it a whirl. SEC takes that approach on pretty much everything having to do this case, so it's not that terribly unreasonable for Ripple to take that approach as well. And in part, Judge Knepper wrote the following. This is on page 3 out of the ruling. I don't feel it necessary to read the whole 4 pages here, although the 4th page is pretty much just a signature line. But anyway, Judge Knepper wrote the following. Estabrook's notes are no different from the notes the court previously found to be protected by the privilege. Garlinghouse's need for the notes is significantly reduced in light of his presence at the meeting, just as defendant's need for the notes previously considered was significantly reduced by Ripple's and its shareholders' presence at those meetings. The SEC's fact-gathering from third parties is not an inherently privileged activity, but having reviewed Estabrook's notes, I find that they could reveal to Garlinghouse the SEC's internal thought process during his meeting with Commissioner Roisman. The privilege applies, end quote. So that's unfortunate. She does acknowledge that the nature of the meeting taken, that on its own didn't make it so that these necessarily would have been privileged. She's saying that does not make it the case, but there actually happens to be writings in here that she believes truly are privileged and the defendants should not have.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.